Good morning, Ms. Mellon. Mr. Lankin, good morning.
Good morning. May it please the Court, I'm Charles Rankin, representing David Morgan in this appeal from a conviction of first-degree murder. I want to try to address three issues this morning: the insufficiency of the evidence on a theory of principal liability. Secondly, the failure of trial counsel to interview, properly summons, and present the testimony of a witness that wholly exculpated the defendant. And number three, the trial judge's error in permitting the prosecutor to give an opening statement outlining the evidence he expected to adduce about a separate charge, ultimately dismissed, that the defendant also conspired to kill one Tanashi Edwards. Turning first to the sufficiency of the evidence. During the pretrial proceedings, and there were extensive pretrial hearings in the days leading up to this trial, the Commonwealth's theory, repeated over and over again, was that this killing was the result of a joint venture between the defendant and one Johnson. And in fact, at the time the jury was impaneled in this case, Johnson was a co-defendant. And at the very end of impanelment, the trial judge severed the cases of Johnson and Morgan and permitted Mr. Morgan's trial to go forward while Mr. Johnson's trial was deferred. Inexplicably, the Commonwealth, at the close of evidence, only pressed for instructions on principal liability. Conceitedly, if believed by the jury, there was enough evidence to go to the jury on joint venture, but the judge did not instruct on joint venture, and the jury didn't consider it and didn't convict on it. So the evidence is set forth in the parties' briefs, and I know the Court has to review that carefully on a very fact-specific issue like this. The Commonwealth concedes that both Johnson and Morgan had the opportunity and the means to commit the murder. But the Commonwealth contends that there is enough in the snippets of testimony about Morgan's statements after the killing.
Well, would you agree that some of the statements are very strong? Well, here's one statement: if no one sees me kill the victim, there's nothing no one can do about it.
There are a number of statements along that vein, but none of them implicate the defendant as the shooter. They all go to the defendant.
If no one sees me kill the victim, there's nothing no one can do about it. No. If the jury chooses to, couldn't they interpret that to be a statement that he was the one who committed the crime?
I think they could certainly infer that he was involved with it. But I don't think they can infer from that statement.
You don't think that's a reasonable inference?
I think that's too far, stretching that statement too far to contend that that alone, or in combination with the other evidence, is sufficient to establish Morgan's liability as a principal.
And then another statement: if anyone tried to rob from me, I would kill them.
That was done, that statement was made well in advance of the killing. And I suggest it was not made with respect to this.
Well, how about this one? He was feeling real messed up because he found out that the victim did not break into his house and someone else did.
Well, that goes to the government's theory. The government's theory is that Roe, the victim, was murdered because Morgan believed that Roe had broken into his house and stolen drugs and money. The evidence was that Johnson and Morgan were together distributing marijuana and collecting money for the sales of marijuana. So that statement, I suggest, does no more to implicate Morgan as the shooter than it does to implicate Johnson as the shooter. So I think that if the Court looks carefully at the different statements, you'll conclude that the evidence was insufficient to point to Morgan as the shooter. All the evidence is that witnesses or a witness saw Roe get into Morgan a car with Morgan and Johnson on March 3rd, shortly before. That was the last he was seen. And you can infer, I suppose, that they then killed him after he got in the car. But who did it? There was no evidence to suggest it. And the court will have to look at the statements carefully in the context of the evidence at trial to see if there was enough to establish principal liability of Morgan as the shooter.
Mr. Lankin, was there some explanation as to why the Commonwealth did not ask for an instruction on joint venture?
You know,
are there any...
there's nothing in the record, Your Honor. It seemed to me from reading the jockeying that was going on before trial that the government was pressing vigorously the joint venture theory in order to get into evidence, to persuade the trial judge to permit them to adduce a number of statements. And once Johnson was severed, and once the judge indicated that he was not going to let the conspiracy to murder Tanashi Edwards go forward, then the Commonwealth backed off of that. One can infer that the Commonwealth was doing this as litigation strategy, but you kind of read this record and you say, I don't know why they didn't press for a joint venture instruction, because it seems to me that a fair reading of the record is that joint venture was much stronger for the Commonwealth than principal.
Maybe that question is best addressed to the Commonwealth.
That may be.
No, I just wondered, if there was some, colloquy, around the instructions.
This is not a situation where the Commonwealth asked for a joint venture and didn't get it, or the judge refused to give it, or
the thrust of the Commonwealth's brief, and I will ask the Commonwealth, seems to be. I mean, it reads like a classic. You can find them as a principal or a joint venture, namely, one sentence, the jury could really conclude that the defendant, more than Johnson, had a motive to kill, that it was more likely that, and is it your position that as a matter of law that's insufficient for principal liability?
Yes, Your Honor. I mean, it's simply, the Commonwealth says Morgan had more of a motive because it was his house that was broken into.
Right.
Well, did Johnson have any motive? I mean, other than that he was Morgan's man.
Johnson was a co-venturer in the drug enterprise, and presumably if drugs and money were stolen from Morgan, that affected his business interest. Morgan described Johnson to one of the Commonwealth's witnesses, as related at trial, as his boy. He's cool. It's clear that they were in this together.
Right. It's clear that they're in the drug business together. I don't think it's so clear they're in the killing together.
Well, the Commonwealth indicted him for murder. They proceeded against him for joint venture murder. The evidence was that the last time Rowe was seen was getting into a car driven by Johnson with...
I mean that there's evidence to get him on a joint venture, but I don't see evidence to establish that Johnson was a principal. It seems to me that Morgan has the motive. Morgan is the one who's mad that his house was broken into. I mean, that's the Commonwealth's theory.
Well, the question is,
and Morgan has this lackey who he brings with him.
I guess you could kind of posit this as a struggle between the Commonwealth and the defense as to whether this is more like Salemi or more like Torres.
Correct.
Torres says, well, there was no evidence that the other proposed killer had any interest in it, anything to do with it. That's different from here. So we say that there's no way to distinguish, for the actual killing, no way to distinguish between Morgan...
But in Salemi, was there any evidence that either of the two men in the restaurant had motive to kill the defendant?
The only real evidence, as I recall the decision, is that Salemi fled. And that the court was quite clear that the fleeing is not enough to say that he was...
It's not enough as a matter of law, plus both of them would have reason to flee. They were there.
Yeah.
So I think this case is distinguishable from Fleming because one of the two men has motive. I mean, he was mad. He went around saying it.
I think when Your Honor looks closely at the transcript, you'll see that both have motive. I think the Commonwealth argues that Morgan had a stronger motive. I don't think that's enough to get to principal liability.
Well, I have to, just to go back to Justice Einen's question, it seems to me that the piece that you have to overcome, which at least the big piece is, I know it was a week before, but at least in the Commonwealth's view, your client told somebody called McLean that he was going to kill this victim.
There was a discussion between McLean, this witness who surfaces at the last minute,
Right.
Johnson, and Morgan, in which McLean is supposedly trying to. There's a display of guns. Johnson has a 9mm gun. The Commonwealth's theory is that it was a 9mm that was used to kill Rowe. So Johnson hands it to Morgan, who hands it to McLean, who hands it back to Johnson. And there's discussion about McLean trying to persuade the two of them not to do the killing. And this discussion takes place among the three of them. I don't think once you look at the transcript, you'll see that that's enough to say, based on that discussion, that it was decided that Morgan was going to shoot Rowe.
Do you want to move to the
I would like to move to the second argument, and that concerns the trial lawyer's failure to take advantage of a pair of police reports that were disclosed early in disclosure, in discovery. Rowe was killed on March 3rd, and his body was discovered at the end of April in a river with a gunshot wound to the head. Almost as soon, within a day or so of the discovery of the body, a woman named Katie Wells went on her own to the Agawam police and said, I knew Rowe, and before the body was discovered, I had conversations with somebody known to me as Mike, later identified as Howard Livingston. And she recites Livingston's statements to her. They're talking about people in the Jamaican community. It turns out that she asks Livingston if he knows colors, nickname for Rowe. Livingston says, yeah, but you won't be seeing him anymore. He's sleeping with the fish and he's got a bullet in his head.
I thought it was more inculpatory. Didn't he say?
Yes, I mean
Didn't he say, I put a bullet in his head?
Yes, he says, I killed him. I mean, not in those words, but that's
So this is not information that he would have picked up from somebody else in that community.
No.
He says, I did it.
Yes.
I mean, that's my recollection.
That is the state of the record. So trial counsel, again, inexplicably, does not interview the witness. Does not.
Can I ask you a question about that? There was an investigator in this case, was there not?
Yes.
The trial counsel had. Is it clear that the investigator didn't interview this witness?
I think the record is clear that he did not.
Was he called at the motion for new trial?
The investigator was not called. Ms. Thompson testified, and my recollection is that she testified that neither she nor her investigator interviewed the witness, Katie Wells.
Did she say why?
I'm sorry?
Did she say why she didn't?
She had no explanation for it.
Well, I take it that she had the investigator serve a summons on the witness to try to secure her appearance at the trial.
Well, she had the investigator serve a summons at the address listed on the police report.
Wrong address, I understand.
The wrong address.
But, I mean, it suggests to me, but she did that, but she didn't have the investigator do any kind of interview as far as the record is concerned.
I think the record is that she told the investigator to go out and interview all the witnesses.
Well, when the Sorry.
Go ahead, Justice Sauer.
The investigator served a summons on the address that the police report gave. So he served it on the correct address.
Well, by the time he served the summons, the witness had moved. It was easily determinable where she had moved to, but the summons was never served on her proper address.
That wasn't the basis of the judge's ruling in the motion for new trial. He says, so what? That evidence could not have been admitted.
The judge said even if
Right.
Katie Wells had been interviewed, even if she had been properly summoned into court, it wouldn't have been admitted because of the failure to show that Howard Livingston was unavailable. And our contention is that Howard Livingston was demonstrably unavailable in a couple of different ways. First of all, the evidence was that he had been properly summoned, at least by leaving a last and usual summons at his proper address. In her affidavit in support of the new trial motion, Ms. Thompson said, that he didn't appear. By the time of the hearing on the new trial motion, she says, I'm not certain. I know I talked to a bunch of people that responded to subpoenas, and I'm not sure if he appeared or not. Our contention is that had he appeared, he would have been unavailable either because of an invocation of the privilege or because he would have denied making the statements that Ms. Wells claimed he made, and that under Napolitano and the cases following that from the appeals court, that would have rendered him effectively unavailable.
Of course he's going to be unavailable. I mean, it's a statement that he killed someone.
Yes.
Well,
yes.
but on the other hand, I mean, the police received this report from Ms. Wells. They went out and they found Livingston, and they interviewed him extensively. And he denied, doing it, denied ever saying this to Wells, right?
There was testimony at the new trial motion hearing by the troopers that interviewed him. Mm-hmm. I'm not sure how extensive it was, but they said that he denied it. He said during the course of his interview that lots of people didn't like Mr. Rowe, and nobody was going to shed any tears about his death, and he denied any involvement in it.
Okay. So it strikes me, I've tried to sort of piece through this. It's a fairly complicated issue.
It
I know
is.
you spent a lot of time in your brief discussing it. But as I looked at the judge's ruling on the motion for a new trial, I get the sense that what he's concluding is it didn't really, at the end of the day, make any difference because her statement would never have been admissible because it simply was not sufficiently reliable, or at least it would not have passed the reliability test.
Well, I don't think he focused on the reliability test so much as the failure to demonstrate unavailability.
Well, that was his first analysis, and then he moved to the Chambers analysis and basically said it wasn't reliable under Chambers. So isn't that the same test that you would have to meet if you were trying to get this statement in as a statement against penal interest?
I think Chambers is a lot softer test than the penal interest law that this court has elaborated. And I think Chambers would enable a court to say, well, even if this doesn't meet a strict definition of unavailability or reliability in the sense that we've elaborated it in the penal interest law, it does, fairness, due process does require that it be admitted. So I don't think that we can conclude that Judge Hillman on the new trial motion excluded it for reliability under traditional grounds. And I think that he basically said there's no basis to jump to the Chambers analysis because our rules of evidence are not arbitrary in the sense that Mississippi's.
I take it your position, Mr. Lankin, and I looked at trial counsel's statements, is that in a case like this, when you've got, I mean, it's not just peripheral evidence, this is rather unusual because here is a witness who knows absolutely nothing about this and actually volunteers to go to the police, that the trial counsel can't simply say, well, it's double hearsay, I don't think you really have to fight tooth and nail to get it in.
Well, that's a position, yes, Your Honor, but here it's not. Judge Hillman, at the bottom of his analysis, kind of adopted something the Commonwealth put up in their response to the new trial motion, that it was strategic, in some way strategic, by trial counsel not to put her on. And I just think that is really wrong. I mean, she could not make a strategic decision not having interviewed her, not having sat with her and seen that she was a credible.
What was the defense?
The defense was that the Commonwealth's witnesses, these 4 witnesses that testified to statements, were not credible people.
So to say, and by the way, there's evidence that somebody else did it, is not inconsistent with
Not
that
at all
defense
inconsistent.
anyway.
No, but let me. I've got Judge Hillman's decision here, and he says the only indicia of trustworthiness inherent in the statement was the timing of the giving of it. In other words, Wells testified that she received, that this Livingston made this statement to her before Mr. Rowe's body was found. Then he goes on, there was no other information in discovery that supported a second look at Livingston, thus making the Wells statement unreliable. I mean, and then before that, he goes through this analysis of reliability. So why are you saying he didn't find the statement to be unreliable under both tests? The Chambers test and the statements against penal interest test.
Well, he also does, in essence, a substantial likelihood test. I mean, he says in any event.
I think that's right.
He belt and suspended it.
I do also want to point out that it wasn't just the incidents of her going to the police right afterwards and having said the statement was made before the body was discovered. It was also the situation that she was friendly with Roe, didn't know the defendant. There's no finding by the judge, and I don't think he would have made a finding, that she was lacking in credibility as a witness. So, I think that...
And the statement was made that his body would be found in the water, which is where it was later found.
Yeah, yes.
Mr. Lankin, your time is up, and I'll give Mr. Townsend the same time. Do you want to touch just briefly on the third one, or do you want to list on the brief?
If I could have a minute to do that, Your Honor, I'd appreciate it. The third issue is that this case was indicted as murder of Roe and conspiracy to murder Edwards. And it was clear from before trial that the Commonwealth was going to have terrible trouble admitting evidence to sustain the charge of conspiracy to murder Edwards.
Why was what the prosecutor said improper, given what he believed at the time? The judge had said that, he hadn't decided yet.
Well, because the judge limited what the prosecutor could say in his opening statement, and the prosecutor went beyond the judge's limitation. The judge was quite specific. The prosecutor's opening, that part of the opening, appears on page 26 of our brief. Okay. And if you compare that with what the judge told him he could do, it was quite a bit beyond it, and it just laid out this whole theory that Jamal Peters was going to...
Did Thompson object?
Thompson had objected beforehand and moved for a mistrial afterwards on the multiple layers of hearsay. So our contention is severalfold on this issue. One is the judge erred in letting the prosecutor go forward without a pretrial determination. The judge, in fact, recognized on day 10 of trial that this evidence was incredibly prejudicial. Those were the trial judge's words. And the next day, day 11, he granted a required finding on that theory on that charge because he determined that Peters would not be permitted to testify because there was no non-hearsay evidence of the conspiracy to murder. So that alone rendered this trial there's some things where a strong instruction can cure. This kind of thing could not have been cured by the strongest possible instruction, and the judge's instructions were not focused on this. They were the typical openings are not evidence kind of instruction. I'll rely on my brief for the rest of that argument.
Thank you, Mr. Lankin. Mr. Townsend?
Thank you. May it please the Court, Thomas Townsend for the Commonwealth. Unless otherwise directed by the Court, I'll address the issues in the same order as my brother. The upshot of the Salami decision is that opportunity to commit the murder is not enough to prove that someone's a principal in the murder. There has to be something more. And the cases from this Court and the Appeals Court have indicated a motive to kill or hostility displayed toward the victim can supply that something more. We have abundant evidence in this case of the defendant's hostility toward the victim and his motive to kill the victim. Even before his house was broken into, the defendant had said if anyone ever robbed him, he would kill him. And he said if the victim ever robbed him, waving a gun, he said, I would kill him. He made that statement to Warren Smith. This was not empty boasting. The defendant was very protective of his property and his drugs. When someone owed him $1,400 for some marijuana and he had not been paid yet, he saw the man on the street and he took a shot at him. He boasted about that later on, a month before Wayne disappeared. After the theft of his residence, he told another friend, Errol Lodge, that he knew who had done it. And he took a gun from his waistband. He says, you will hear about the person.
Mr. Townsend, I think we can practically all concede that this is somebody who makes threats and, he's involved in illegal activity. He's involved in illegal activity, which happens to be where people don't pay, they need drugs, and you stake out your position very, very strongly. is that sufficient to say that he was the principal as opposed to the person who'd originally been his co-defendant?
I think there's no reason Johnson would have to harm or injure Wayne. It was the defendant's residence that was robbed. It was the defendant who was hostile. It was the defendant who was missing the drugs and a gun.
Is there somewhere in the record that we can understand why the Commonwealth decided to proceed on theory of principle only?
I believe the record would disclose that our theory was always that the defendant was the shooter, and others may have been joint venturers.
I understand that may have been the theory, but you can do it on both. You can do principle and...
Right, but I think the evidence that he was the shooter is substantial, and it could properly undergird a finding that he was the principal.
Can you continue with the other evidence that would indicate that he was a shooter? So he made a few threats.
He made a few threats. He told another friend, Richard McLean, straight out that he was going to kill Wayne. McLean arranged hastily arranged a meeting at his workplace with the defendant and pleaded with him not to do it. The defendant said, as was mentioned earlier, if no one sees me do it, nothing's going to happen. This was relayed to Wayne. He did tell Wayne after he met with Wayne on that Monday, 2 days before Wayne's disappearance, and he suspected Wayne. He said, did you have anything to do with it? Because whoever did is going to get it. That was the Monday. And also at the meeting that same Monday with Richard McLean, where McLean tried to dissuade the defendant from killing Wayne, the defendant, in addition to saying that if no one saw him, nothing could happen, he said Wayne would be dead within a week. Sure enough, 2 days later, Wayne was missing, and he was last seen in the company of the defendant. The defendant had access to 2 guns that could potentially have fired.
And the co-defendant.
And the co-defendant. But there's no indication the co-defendant...
But again, the case that you're making is it is more likely than not that it was this defendant and not the co-defendant. And is that sufficient?
I believe, and if I could reference an appeals court decision that would back me up on this one, Commonwealth versus Farrar, which is in my brief. In that case, the defendant and a friend went into a Dunkin' Donuts. The defendant picked a fight with someone. They decided to take it outside. That other person got the better of the defendant in the fight. The defendant and his friend went into a car, the friend driving, the defendant in the passenger seat. The car backed up, the light went on, the light went off. It pulled up to where that other man was. A shot came out of the car through the passenger side window. It was unclear who fired the shot. But the appeals court held that because the defendant had more of a beef, more hostility toward that person, the jury could conclude that the defendant, in addition to whatever likelihood that would come from the passenger seat, although it could not be excluded that it did not come from the driver's seat, that was enough, based upon that, to conclude that he was the principal. There's cases from this court. Torres is a good case. In that case, there were 2 people, a mother of 3 and her live-in boyfriend. The boyfriend had beat the children. The mother had beat her 2 older children, but not the baby. The baby ended up dead. There was 2 possible suspects, the defendant or the mother. This court held that because the mother had never displayed hostility toward the infant, the 12 or 14-month-old, but the defendant had on repeated occasions, including on that day, it was proper for the jury to conclude that the defendant was the principal and had inflicted the fatal blows on that baby, even though the mother had beaten the other 2 children. In that case, the defendant had also made some statements later on that was not medically consistent with the evidence, but the primary motive or the primary reason that the defendant was, or the evidence was sufficient to find the defendant guilty as a principal was his exhibited hostility toward that baby, not shared by the other person, although she was there. I think that's a good case. And I cited a couple other cases in my brief which demonstrate that hostility and motive can supplement, and it can take it out of the realm of Salemi. In Salemi, there are 2 people seated with the victim at a table. They were the only people in the restaurant. The waiter had seen them and then had left, and then 10 minutes later, the victim was dead. He was shot through the head and was seated at his position at the table. There was no evidence showing any motive. In fact, 3 men had been talking friendly moments before. There was some consciousness of guilt evidence, as mentioned exhibited by the defendant, but there was nothing to show that he had a motive or hostility to the exclusion of the other man present. That is not present here. The defendant had a lot of hostility. Even after Wayne's death, in his interview with the police, he said, "You can't trust Wayne because he would rob you." He still had hostility and contempt for the victim even after the victim's death. The victim was recovered 2 days before that. I think in light of this evidence, and in light of the fact the defendant had access, had been seen in the weeks prior to the shooting with 2 of the guns that could potentially have fired the bullet.
Am I correct that the evidence is that the last person that there's evidence as to who had that gun was Johnson?
Well, the defendant and Johnson.
I thought the defendant had handed it
He had
to
handed
Johnson.
it. This was at the meeting where Richard McLean on that Monday.
The last we know of where the gun was, it was in Johnson's
Right.
hands.
The defendant
correct?
said, give me the gun that I gave you, the 9mm. He took it, gave it to McLean. McLean looked at it, gave it back to the defendant. The defendant gave it to Johnson. That showed at a minimum that the defendant still had potential control and authority over the gun, even though he had said he had given it to
It
Johnson.
also shows that Johnson.
That could have been the murder weapon. We don't know if it was a murder weapon. It could have been a .357. The defendant was seen with a .357 weeks or
There was
days
no
before the
ballistics
murder.
evidence?
No
There
murder
was
weapon
ballistic
ever
evidence,
recovered.
no murder weapon, but the
ever
bullet.
recovered.
We do know that it was a weapon capable of fire. It had 5 lands and grooves with a right twist. And there's certain, based on the bullet recovered from the victim's head, that it could have been a 9mm, could have been a .357. We didn't subscribe to a particular theory. We said the defendant had been seen with both in the days leading up to the murder, and we didn't subscribe to a theory that it was a 9mm or was a .357.
Regarding when the defendant made the comments after he found out that someone else had actually broken into his home, did he make any statements that seemed to implicate himself?
Yes, well, he was very upset. He said he was all effed up because the victim had died for the wrong reason. He found out that a person named Stretch had broken into his home, and it wasn't the victim. So that shows that the motive underlying the murder came to fruition. Also, interestingly enough, the very night the victim disappeared, there was a person who was present when Wayne got into the car in Arrow Lodge. The defendant called up Arrow Lodge that night, and he was very frantic. It was a very unusual phone call. He usually didn't call him, and not for any length of time. He said, "Did you hear what happened? I can't find caller. His wife reported him missing." Now, that was an untruth. His wife wouldn't report him missing for another 5 days. But he wanted to ingratiate himself with Mr. Lodge because he knew that he was an eyewitness to Wayne getting into the car.
Mr.
And so-
Thompson, is the defendant correct that he never admitted liability as such?
That the defendant never admitted.
That, you know, in the post-killing period, that he never said, "Yeah, that was me," or "the guy deserved it," or "I told you I was going to do it," or, I mean, which would be very consistent with all of the stuff that he'd done beforehand.
Well, he never came out and said, "I killed him." He did say that 9mm was used to kill Wayne. He did say that he felt all effed up that Wayne died for the wrong reason. He, in the phone call I was just referencing to Mr. Lodge, he said that people are saying that I killed Wayne. Now, that was a manufactured rumor by the defendant to ingratiate himself with Mr. Lodge. If Mr. Johnson had actually done the killing, there was no reason for the defendant to place himself in the murderer's role, in the murderer's role. But he put himself in that role by saying, "There's a rumor, people are saying that I killed Wayne," which wouldn't make any sense unless...
Sure it would if he'd spent the preceding couple of weeks telling everybody in sight that he was going to kill Wayne.
Or he could have said, "People are saying that we had killed Wayne," or some of the people are saying
Let
that...
me understand this again. This was a phone call that the defendant made to Mr. Lodge.
Yes.
Mr. Lodge had actually seen the victim get into the car with the defendant and Mr. Johnson.
That's correct.
And that was the last time the victim had been seen.
Yes.
And this phone call was made that evening?
That evening.
All right. And in essence, Mr. Morgan said to Mr. Lodge, we dropped, there's a rumor that I killed him, but we dropped him off.
Right.
And we don't know where he went after that.
Correct.
So
He
that
didn't
was-
want Mr. Lodge going to the police.
And he basically also said that the victim's girlfriend had reported him missing.
Correct. His wife.
His wife had
Which
reported
would-
him missing, which was not true.
Which she would even know he was... She couldn't get in contact with him, but she thought he had gone to sleep that night.
Right, so she didn't report him missing
Not
actually for
until
5
the
days.
following Monday. yes.
Okay. So in your view, the jury could have interpreted this as Morgan trying to, in essence, establish some relationship with Lodge, explain away the fact that Lodge had seen him pick the the victim up.
Correct.
And a jury could have reasonably concluded that was the case.
And there was more than just that phone call. That was just the tip of the iceberg. What he had done for Lodge, he had been arrested, or he would be arrested with Lodge later on marijuana charges. And he was very frantic, looking pitiful that Mr. Lodge would testify against him. He said, "You can't testify. Please don't testify against me. I'll get you out. I'll bail you out." The defendant was bailed out. He tried to arrange bail for Mr. Lodge, saying that he would pay the bail. He got in contact with Mr. Lodge's girlfriend, inquired what the bail amount was, learned it was $10,000, instructed her to go to a bail's bondsman to try to get it lowered, got it lowered to $6,000, said that he would take care of it. However, they later learned that there was a detainer on him, an immigration detainer. He got his lawyer to go see Mr. Lodge and to meet with the girlfriend to try to take care of the detainer. The lawyer met with the girlfriend for about 45 minutes. The defendant paid the bill. The lawyer thereafter met with Lodge 3 or 4 times. During this period, from their arrest through September, he had daily contact with Mr. Lodge's girlfriend. He gave her money when she said she was short on money, she had to move. He provided her money. He promised that he would take care of them, meaning her and Mr. Lodge. Mr. Lodge learned of this and called up the defendant and thanked him. This was a way to ingratiate himself with Mr. Lodge. He broke off the daily contact with Mr. Lodge's girlfriend after he learned in mid-September that Mr. Lodge was thinking about testifying against him in this case, or at least he perceived that.
Don't you think if you were defense counsel representing the defendant, you might instruct your client not to start talking to witnesses on the other side?
I think that's
Doesn't tell me anything. And
Well,
once he learns that he's going to be a witness,
Well, I mean, the jury could have interpreted that he was trying to ensure Lodge's silence.
Right. He was
That's
trying to
the
buy
point.
his silence through deeds and money and through legal assistance by his lawyer. He provided that, and once he found out that it wasn't going to work, he pulled back, and soon thereafter he was arrested.
Do you want to move to the second question?
Yes. There are several problems that mar the defendant's argument. First is that it has not been demonstrated that Livingston was unavailable. All that had been done for Mr. Livingston was that a subpoena had been sent to his residence. To be admissible as a statement against penal interest, the first prong of that analysis is whether someone is unavailable.
I understand that, but this seems quite circular because the reason why he couldn't be demonstrated as unavailable is that defense counsel was ineffective in ensuring, A, his availability, or B, that she could establish he was unavailable.
Right. Well, the ineffective claim is premised on the supposition that if he were called to testify, he would assert a privilege and therefore be deemed unavailable. That is an unwarranted presumption. One cannot assume that someone is going to be assert a privilege, especially in an instance like this where he had given a formal statement to the police in which he denied any knowledge of the crime. So I don't think we're in a position, as in, say, the Charles case, where we can assume that he would have asserted a privilege. It's one thing to assert the privilege. It's another thing to presume that someone is going to do that, and that's an unwarranted presumption. So I think they failed to meet the unavailability requirement. Even if we deal with this on federal constitutional grounds, the Chamber's decision.
But can we just step back that for
Sure.
1 second? Let's assume that defense counsel had served a summons on Livingston. Livingston didn't show up. She had her investigator go out, make further attempts to find him, couldn't locate him, came back and reported to the court. Then he would have been unavailable. Right?
That would have been different. The standard is
Well,
substantial
okay.
diligence.
Okay, so that would have been different. So if she'd done her job,
If she,
that would have been different.
Right.
Isn't that the implication? If she'd done her job properly as a defense lawyer, it would have been different.
right, but then we get to the next step. Would he still have been deemed unavailable for the admissibility
maybe
of the
yes, maybe
statement?
no, but maybe she puts him on, maybe he testifies and says, I never said that. Not surprising. Can't counsel argue? I'm not going to, in front of a jury, I'm going to do one of two things. I'm going to take the fifth, or I'm going to deny that I ever said that I killed the man.
And the difference there is if he does take the fifth, he could be deemed unavailable on evidentiary grounds, and therefore satisfy the
He's
first
not
prong
gonna-
of the...
One can almost assume that he's not going to do that because he's already spoken to the police. So he's going to be there testifying to the fact that he never said that. isn't
Correct.
he?
And therefore...
He never said it, or it was misunderstood.
That he never said it. Presumably, if any presumption is being indulged, it's that he would testify in accordance with his police statement. I don't think we could assume that he would testify in accordance with what Katie Wells said he said. And if he does, therefore...
It is rather extraordinary, isn't it, Mr. Townsend, because before the body is discovered, so nobody knows anything about rivers or waters or how the killing occurred, somebody makes a statement that says, that is consistent with what in fact happened.
Right, and that's the only thing the statement has going for it.
Well, it's not the only thing.
Well, it's the timing.
It is what makes it such a critical statement.
Well, it does, but as Judge Hillman said in denying the motion for new trial, there's no other evidence at all linking Mr. Livingston to this crime. His name doesn't appear at all during the police investigation. He's never shown to have a motive against the victim. He's never shown to have access to guns. He's never shown to be in the vicinity of the crime, or there's no iota of evidence other than Ms. Wells' statement that he was at all involved in the crime. And that kind of leads to the ineffective claim, because Judge Hillman had also found that because of this lack of other corroborating evidence, that Attorney Thompson would have been justified in not giving a second look to Mr. Livingston, because it was so ripe for discrediting that it was...
You can't say something is ripe for discrediting until you investigate.
But to some extent, she'd have to rely on the investigation of the police. And the police were certainly interested in Mr. Livingston. They interviewed him, and they followed up on it, but they found nothing to corroborate Ms. Wells' statement.
When you say they followed up on it, tell me a little more about that. Was there evidence produced in discovery about follow-up investigation into Mr. Livingston's story and Ms. Wells' story?
Well, I think what we have on the record is that the police interviewed Ms. Wells.
Yep.
They put Mr. Livingston in a photo array. She was able to identify him. Mm-hmm. They talked to Mr. Livingston. He denied any knowledge of the crime. He gave a statement.
Did he give an alibi?
He didn't give an alibi. He gave a statement, explained his association with the victim. It was more of a hi, how are you kind of thing when they met, nothing more than that. He was aware of the victim's disappearance, but nothing more than that.
Did he deny the knowledge about the conditions of the body, that he was shot in the head and it would be the body was in the
Not
river?
specifically. He denied any knowledge of the crime at all.
And what was the follow-up by the police?
Well, after that, the continued investigation, the defendant wouldn't be arrested until the following September.
No. What was the investigation of Mr. Livingston, you said, and then there was a follow-up investigation?
Well,
What was
as
the
part of the
follow-up?
general murder investigation.
No, what
And-
was the follow-up of Livingston? What did the police do to see whether or not Livingston, did he have an alibi? Where was he on that night?
I don't think that's in the record. They took a statement from him. They did a general investigation because they still didn't know who had done it. In the following months, as part of the general investigation, they concluded that it was the defendant based on the evidence, and they arrested him that September.
But how did the woman who had supposedly quoted Livingston, how did she know? I mean, if Livingston denied making the statement, did they go back to the woman and say, he denied making the statement? How do you maybe you know this from some other source. Did they follow up that way?
I don't have any specialized knowledge, and in the record, all we have are her two statements to the police. I think she testified at the hearing that the police never re-interviewed her after that, and defense counsel had not interviewed her either.
Yeah. So she testified that neither defense counsel or investigator had interviewed her after that?
Correct. That's correct. I see my time is almost up.
It is
Like
up.
the-
Do you want to comment as I gave Mr. Lankin the opportunity? Or do you want to
As
rest
far as
on-
the opening statement goes, I will primarily rest on my brief, other than to point out that there's a good faith and reasonableness standard that is indulged, and Judge Hillman found that the prosecutor was both reasonable and acting in good faith. And also that the reference to the, I just want to point out, the reference to the conspiracy comprised only 2 paragraphs in a very long 32-page opening statement. And that was 10 days before the jury would receive this case. So there was some time that elapsed. So I think it wasn't, I think in light of the judge's cautionary instructions that opening statements are not evidence, I don't think there was any risk that the jury would allow spillover effect in this case.
Thank you, Mr.
Thank you.
Townsend.